Good afternoon. I'm Kristen Savell, Co-Executive Director at the Rock Center for Corporate Governance at Stanford. Thank you for joining us today to talk about the reincorporation dilemma should your company move out of Delaware. This is an issue that's been top of mind for many companies lately and one that has dominated the news in Delaware, where the governor just last week signed into law Senate Bill 21, which purports to address many of the concerns that have prompted some Delaware incorporated corporations to exit the state for jurisdictions perceived to be more business friendly. So today we're going to cover why reincorporation has become such a hot topic, the advantages and challenges of reincorporation, including key differences among the various jurisdictions, the process for reincorporating and strategies for mitigating litigation risk, and key takeaways for business looking to incorporate or reevaluate their state of incorporation. We will reserve some time at the end of the session for audience questions, so please feel free to add your questions to the Q&A area. You can also upvote questions submitted by other participants. I will not be separately monitoring the chat feed, so please don't put your questions there. Okay, I am joined today by an excellent panel of speakers. I'm going to ask each of them to briefly introduce themselves, and then we can go ahead and get started. So Amy, why don't we start with you?
Thanks. I am a partner at Wilson Sonsini in our Delaware office. I serve on the firm's board of directors. I chair our firm's corporate governance practice. And just for context for what I'll be talking about, from my vantage point, my advice, my practice focuses on corporate advice and transactions. I predominantly focus on Delaware law and corporate governance, but get involved in other jurisdictions too. And I was fairly involved in the amendments process in Delaware, so I've got some insight into that.
Great. Kristen?
Hi, everyone. Kristen Seeger. I am a partner with Sidley Austin in the Chicago office. I serve on the firm's executive committee and lead our global commercial litigation and disputes practice. And I focus my practice on shareholder and corporate governance litigation, as well as board investigations and special committee representations that are related to companies' highly complex governance and business challenges, and have definitely had a role in some of the reincorporation issues that we'll be discussing today as well.
Great. And Grant?
Hi, everyone. Grant Reed, Deputy General Counsel and Secretary at Atlassian. We're a publicly listed enterprise software company based in San Francisco. And since September 2022, Atlassian is a Delaware corporation as our second redomicile. I should note that I'm speaking here today in my personal capacity, and my views may not reflect those of Atlassian or its board.
Kristen, I'm hoping you can help set the stage for today's conversation. Why are we talking about reincorporation right now? What has changed? Is this a new debate or more of a resurgence of ongoing competition among the states?
So this is a great question because even 5 years ago, we were really not talking about reincorporation in this way at all. Delaware was very dominant across the board, along with some number of corporations that have always chosen to incorporate in their home states. So it can be easy to think of Delaware as having always been dominant, but it's not true. And there's a very American story here of competition among the states for dominance. If we turn back the clock a bit to the late 1800s, New Jersey was absolutely dominant. It had 95% of incorporations, but it over time made some moves that set it up to lose that monopoly, and innovation by other states, including Delaware, came in to aggressively compete with New Jersey. And the Delaware story started then and really accelerated later in that century with the adoption of the DGCL, the modern version in 1967, really provided a springboard for Delaware to surge. And it was approaching half of the 1,000 largest incorporations by the mid-70s. But then the real high watermark came after 1986, as we all know, with the adoption of Section 102B7 and allowing for exculpation of director liability for violations of the duty of care. Delaware truly surged to the top. It's been interesting over time. Other states have generally then followed the law that Delaware has adopted substantively, keeping up with its changes over time. So the substantive corporate law in the United States really has converged across states over time. And Delaware, as we all know, has long been distinguished then by its courts, including the Court of Chancery, which is the most sophisticated business court in the country, also distinguished by its legislature's willingness to address corporate concerns or judicial overreach when necessary. And I think one reason we're talking about all of this today is because one thing Delaware promised over the years was a really high degree of certainty in its law, and people wanted that and recognized it. And there has been a story of more concern over the past few years with certain decisions coming out of the Delaware courts and the burdens that directors and corporations felt from those. And so we've seen directors and companies really struggle with some increasing uncertainty of how they think their actions will be assessed after the fact, as well as some concerns about the balance of fiduciary duty litigation and how it has shifted in ways that felt very burdensome and expensive for large corporations in particular. And so I think historically, much like the moment that I mentioned that New Jersey faced a century ago when its monopoly began to crumble, and Delaware swooped in to compete there, in the last few years, other states have seen a real opportunity to compete with Delaware, and they've taken that opportunity. And so there have been high-profile departures in the past few years, in particular to Texas and Nevada, that have drawn a lot of attention. And I know on this panel we discussed in advance, we've all seen companies becoming much more willing to reconsider whether their prior selection of a state of incorporation continues to be the best choice for them under current circumstances.
Great, thanks, Kristen. That's very helpful. I'm sure many people in the audience have read reports over the past year about companies reincorporating or stating an intent to reincorporate outside of Delaware. Amy, what do we know about these companies? Are they public or private? Do they tend to be controlled? And roughly, how many companies are we talking about?
Yeah, so I would say that what's unusual from the last year or so is that we've seen several large public companies either reincorporate or announce that they're planning to, or have the news leak that they're considering it. And so that includes Tesla, moved to Texas. Elon Musk was very upset with the compensation decision and moved all of his companies out of Delaware, as most of us know. The Trade Desk moved from Delaware to Nevada. Dropbox moved from Delaware to Nevada. We were involved in those last two. TripAdvisor had a very public situation where they were seeking to move to Nevada. I think they still might, looking at their disclosures. They went through a lot of litigation in Delaware over that. Simon Property Group announced a couple of weeks ago that they've got a pending proposal to their stockholders to reincorporate. These are big companies, big market caps. And you didn't usually see that kind of movement out of Delaware. Of course, news also leaked that Meta was considering moving out of Delaware, and we'll see what happens there. I have not had, in my experience, private companies reincorporate yet, but what did trouble me as a Delaware lawyer, and I have been a Delaware lawyer my whole career, so I do admittedly have that bias, is that before Delaware announced its new statutory amendments, the conversation was spreading, and it was spreading fast. And we were starting to get the question from private companies, including pre-IPO companies, and that was new. And then in addition to that, you saw a lot of discussion in the market in a way that you're just not used to seeing. And that included, we had major investors like Mark Andreessen and Bill Gurley question whether companies should stay in Delaware. Law firm slides comparing Delaware and Texas and Nevada were circulating on X. I was seeing the conversation start to creep into IPO prep decks, whether you should stay in Delaware. Some law firms were putting out startup incorporation forms for Nevada. So I would say we're still in the relatively early days of reincorporations, but the market chatter had really, really picked up. And privately, I had a lot of companies coming more and more to me. So I think, these were all the reasons why we've seen a lot of seriousness grow around this conversation. I should also note before I stop that if you look back over the last couple of years, there are actually quite a few smaller public companies that have left Delaware, life science companies, some other industries, but the ones I mentioned by name are the ones that really caught people's attention, including the attention of the Delaware governor.
Mm-hmm. All right, now we've set the stage. We understand why reincorporation has become such a hot button issue. I want to explore how business leaders should approach a reincorporation decision and what factors may be relevant to that analysis. And Grant, let's start with you. You're in-house at Atlassian. As you noted, Atlassian has redomiciled twice already, once from Australia to the UK, and then from the UK to the US. What are the key factors that business leaders should consider in deciding whether to reincorporate or stay put?
Yeah, it's a great question. So I'd start by saying I don't think there's a single board director or CEO who gets out of bed any morning and wants to think about this topic. Either it happens because they feel like they're on the receiving end of some bad law or court decision, or because they can't achieve the business objectives they want in the place they're incorporated. So I think for Atlassian, prior to our IPO in 2015, there was a feeling that in order to access deep capital markets, we needed to be outside of Australia. At that time, doing a large software IPO in Australia was probably not possible. And then moving to Delaware in 2022, sort of similar story. So access to capital, deeper United States capital markets, inclusion in indices with the rise of passive investing is only open to the largest swath of investors if you're based in the United States. So we sort of looked around for a place in the United States to reincorporate, and Delaware was the obvious answer, as I think it was to many up until that point, for its all the reasons for the Delaware system touts itself today, which is highly specialized, knowledgeable business courts, dependable rule of law, all the sort of things that the state, I think, has a well-earned reputation for. So we went to our stockholders and we went through a process to move the company, and we're successful in doing so. And I think we've seen the results of those in terms of access to capital market, which has been great, and also access to sort of the enhanced corporate governance features of a modern corporate governance system.
Let's dive into the differences between various jurisdictions so we can have a better sense of what is at stake for companies that are considering a reincorporation. And that analysis is going to look very different today than it did a few weeks ago. Now that Delaware's governor signed into law Senate Bill 21, which makes some pretty significant changes to Delaware's corporate law. So taking these changes into account, Kristen, can you walk us through some of the key differences between Delaware, and let's focus on Texas and Nevada, which you also identified previously and which seem to be the two jurisdictions most frequently cited as alternatives to Delaware?
Yes, absolutely. And Amy should also feel free to jump in if she wants to discuss specific things in the law, given her involvement and familiarity there. But as we think about distinctions between Delaware now and Texas and Nevada, there are certain categories that are just really not a meaningful driving force in terms of differences, but both the court systems and parts of the law are things we should highlight here. So as noted, Delaware has by far the most well-developed court systems of these three jurisdictions, but Texas now has its business courts up and running, and Nevada has announced that its legislature is considering a constitutional amendment that would create an appointed business court there as well. And we definitely still see Texas continuing to innovate around areas of concern that it has identified in Delaware law, and looking at aspects of its own system that can be viewed as potentially concerning, such as having jury trials for shareholder cases. And so I think one very important point about the recent changes in Delaware law is that it's just not going to be the last word, and that Texas and Nevada have shown a real commitment to compete and to innovate, and will keep doing so. And some other states are as well. When we look at questions of case law and where it is more developed or less developed, this is one of those places where the answer right now is really shifting. And I would have said, of course, Delaware is dominant in terms of body of case law, and it still is, but there's a lot of interesting discussion this week, and I think this is a topic I'd love to hear more from Amy on too, of the extent to which the new Delaware amendments overturn case law and create more of an open field for figuring out exactly how Delaware law will continue to play out. There are ways in which it is probably shifted now much closer to what you would find in terms of holdings, particularly in Texas. Texas does not have as many decisions as Delaware, but There are some advantages there too, like less variability in them, which, you know, we know can be better for larger or more innovative companies. And it has definitely long been the case that companies think hard about the standards-based approach that the Delaware courts take, because it does impose more uncertainty on large companies in particular that are likely to just be more repeat targets for litigation, as well as for innovative companies that are more likely to engage in novel transactions, you know, that don't fit the pattern of previously litigated cases. So it can be hard to understand how that law may map on to you. I do want to talk about fiduciary duties and liability exposure, but I want to pause for a minute just because I do think it'd be interesting to hear from Amy a bit on how she's thinking about the new law, and in particular, how it may affect the body of cases and thinking about these distinctions with other states.
Yeah, thanks, Kristen. So what I would say is, first of all, when clients reach out to us and they want to talk about Delaware versus other states, should I reincorporate? What do I need to think about? The topics that I think they most want to talk about are the following, in no particular order. It depends on the company and what they're focused on. But the treatment of controlling stockholders and conflicts of interest, fiduciary duty standards for directors and officers, inspection rights under the books and records statutes. What's the focus of fiduciary duties? Is it stockholders? Is it other constituencies? What's going on with the business courts across, say, Delaware, Nevada, Texas? Does a state have a statutory focus to its law or a case law focus to its law? And plaintiff's fee awards. And what I would say, you know, without going too deep, but I think it helps set the stage for the Delaware legislation, is that if you look at Nevada, Texas, and Delaware, you know, those are the big three people are talking about, but certainly not the only ones. The treatment of controlling stockholders is different. You know, even under the Delaware new regime, controlling stockholder conflicts of interest still trigger the entire fairness standard of review. They're recognized as a real conflict. In Nevada, not so much, based on my conversations with Nevada counsel. There's no automatic entire fairness, no required cleansing mechanisms just because you have a controller conflict. The D&O exculpation standards are much more favorable in Nevada. Texas is legislatively attempting to move toward that. Delaware is not that. Delaware still has pretty robust inspection rights, if you ask me, including under the new regime. In Nevada, based on my conversations with Nevada counsel, there are essentially no inspection rights for Nevada public company stockholders. So there are still real differences across the jurisdictions, and I could go on and on, but I won't in the interest of time. I will say Texas caps plaintiff's fee awards. Delaware does not yet, although there's a study pending in Delaware on that issue. So it's important to get down into the nitty gritty and understand those differences. But what I think it's fair to say the Delaware statute does now, you know, at a high level, is to say there are still controlling stockholder conflicts of interest, but the statute defines what it means to be a controlling stockholder in much clearer ways that had become really indeterminate under the case law over the last 10 years. The statute clarifies the processes, this is the new Delaware statute, clarifies the processes for cleansing controlling stockholder conflicts of interest. Under the MFW and match case law that a lot of you have probably heard about, you had to use a minority vote and an independent board committee, and there were a lot of bells and whistles around how you did that made it pretty hard to comply with the framework in a lot of situations. Now under the statute, you need either an independent committee or a minority vote for most transactions, unless it's a going private. And some of the footfalls have been eliminated. I can tell you just from the last week alone, it is a lot easier and a good way to plan transactions, but there are still guardrails. The mechanisms for cleansing D&O conflicts under the statute have been clarified. And so, you know, those are proving to be workable very fast. There's a heightened presumption under the new Delaware statute for being an independent director under Delaware law. So if you're a public company director deemed independent under stock exchange rules, you get a pretty good presumption under Delaware law now that you're independent for Delaware purposes. And then finally, the books and records statute was revised to try to take that right that stockholders have outside of the litigation context to inspect books and records back to being focused on the core records of the company, which is like the governing documents, annual financial statements, D&O questionnaires, and board minutes and related board records. So, you know, we could spend an hour on the Delaware statute alone, but that's what I think the statute is trying to do. But Kristen, would love your thoughts on everything I just said too.
Yes, I actually said before this, I'm so excited to talk to Amy in this with all of you because everything that's happened in the last week is quite interesting here. I agree with all of that, and I think when we ask this question about Delaware, Texas, and Nevada, which are the three states keeping themselves most in this conversation, although as Amy noted, there are a number of states innovating right now and looking to become more of a destination. We have seen Delaware acting very quickly in the past year to, on multiple occasions now, try to make legislative changes in response to judicial decisions. And I think that both is, obviously important and shows Delaware's willingness to innovate and try to stay a market leader, but also shows the effect that states like Texas and Nevada have had through the pressure that they are applying by being willing to innovate themselves so much as well. And I think there's a really interesting question here of whether the Delaware amendments have sort of put this competition to bed. And I think the answer is probably no. Will it be enough to stop some number of people from thinking about leaving? Absolutely. But there will, I think, be a really interesting period. And Amy, you pointed this out, where there has been a fair amount of overturned case law now, I think, from these amendments. And so there will be a period of redefining what will apply and how it will apply. And, there are, even in the amendments, are some standards-based issues that are going to have to be unpacked by the courts. And, it'll be interesting to see whether there are ambiguities found there. For example, even with the helpful changes to understanding what a disinterested director is, you can still rebut that presumption with substantial and particularized facts, and understanding what that's going to mean and how prior cases will map on to that is going to be, I think, a meaningful, interesting issue over the next period of time here. It's also, much easier now, post TripAdvisor and post amendments, for a controlled company to leave Delaware if it wants to. And so I think that's going to take a little time to shake out as well in terms of how companies with controllers will think about the issue.
Can I just jump in here, Kristen? So you mentioned, for example, changes around what it means to be controlling stockholder. How does that compare to Texas or Nevada? You discussed what it looks like under the current Delaware iteration of the law, but how does that compare? And I guess I'm interested to understand that in relation to controlling stockholders, in relation to what it means to be disinterested, and then also understanding differences around inspection rights.
Yeah, so I'm going to tag team this one with Amy, because I think she's done more recently the deeper dive into, in particular, thinking about the books and records issue on the disinterestedness and independence of directors as well as controllers. Nevada is by far the friendliest regime, right? I mean, it is different than Texas or Delaware on that. And that in 2020, the Nevada Supreme Court confirmed or interpreted its applicable statutes to say that gross negligence-based allegations do not state an actionable claim against corporate directors or officers. So that is a meaningful difference for Nevada. The presumption of good faith there just means that a conflict of interest transaction involving a director or officer is not going to be viewed through the heightened scrutiny entire fairness lens. And even if it's easier to cleanse some of those things now in Delaware, it is not what the regime is in Nevada. Amy, do you want to comment on the books and records piece?
Yeah, sure. So under Delaware law, inspection rights, Section 220 of the DGCL, the Delaware statute, are frequently used advice statute. A lot of people on the line have probably woken up to a 220 demand by stockholders seeking books and records, and you can get those records if you have a proper purpose, which can be to investigate wrongdoing, to value your shares, things like that. And about 10, 15 years ago, the Delaware court started really encouraging stockholders to use those rights before they filed litigation. And stockholders took the courts up on that, and so did plaintiffs' lawyers, right? And so these rights were being quite robustly used under Delaware law, and we had cases in recent years that were more willing in some contexts to allow access to emails, to text, to other types of records in this 220 outside of litigation context. And there was, I think, a strong market feeling that it was just going too far, and this was supposed to be a contained summary right. And so I think the statute that we have now, new law as of March 25th, brings it back, accordion style to a more contained right like what we had 15 years ago. But, I'm not a Nevada lawyer, I'm not a Texas lawyer, but my understanding from talking to counsel there and working on some reincorporations is that in Nevada, you really have basically no inspection rights as a public company stockholder. You don't get the sorts of things that I'm talking about in Delaware. Private companies can work differently, but there are still thresholds and things like that that are more company favorable. And then Texas, Texas is in the course of sort of modifying itself legislatively. When I would talk to Texas counsel in the last many months, they would say Texas is kind of somewhere between Delaware and Nevada. And so I think you might see that with inspection rights there too. But for example, Texas just introduced a package of legislation in the last month or so where they're taking their D&O standards and trying to move identically to Nevada. So, and that says things like, D's and O's cannot be liable unless there's been a rebutting of the business judgment rule and there's fraud, knowing violation of law, or intentional misconduct. That's something you see in Nevada that Texas is now trying to move toward in terms of protecting directors and officers. Delaware is not that. So we're seeing movement, real time, long story short. But the other thing I want to touch on quickly that Kristen talked about is just to put it in concrete terms, for people listening, that if you look at the Delaware case law, take the Elon Musk case that we can all sort of understand easily. That was a case where there was a controlling stockholder. The court said it's a conflict. Entire fairness applies. If you want to get back to the business judgment rule, you need a committee and a minority vote done just the right way. If not, the court gets to look at these things at trial, which is what happened in the Elon Musk case. And then the $56 billion comp package was rescinded. So that's what Delaware law had moved toward in the most colorful example. But there's a Nevada Supreme Court case saying you don't get entire fairness just because there's a controlling stockholder conflict of interest. We don't do that in Nevada. And in that same case, there had been what seemed to be a decent independent committee process run by the company, and the case got dismissed because of that committee process, even though there was a controlling stockholder conflict. So I tell you those two cases is just an example of how in the last year, clients have been more willing to look at how these bodies of law work.
So I think we got a little bit of Kristen's perspective on this, but Amy, how do you think these changes to Delaware law impact the reincorporation analysis? Somebody in the audience asks, similarly, is the impetus to reincorporate just dead at this point?
Well, the Delaware lawyer in me would like to say yes, but I wear other hats at the firm, right? And so what I would say from practice is the legislation definitely had the effect of pausing conversations, quieting them in many, many instances. And I think a lot of clients, and by that I mean a broad panoply, right, of boards, management teams, GCs, investors. I think most clients are saying, let's pause, let's give Delaware time. These are meaningful amendments. Frankly, I've worked with some GCs and boards where they don't really want to move either. And it's almost like they're heartened that Delaware has given them a reason to stay. But on the flip side, we are still getting the questions. As Kristen alluded to earlier, now that the conversation has happened, I'm not quite sure you can put the genie back in the bottle in all respects. And we do have a couple companies in our client base that I think are still likely to reincorporate. And I've heard from other lawyers that they also have that in their client bases. So I think we will see more movement in the next few months or year.
I don't want to delve into the pros and cons of the recent changes to Delaware's corporate law because that debate is outside the scope of this webinar. But Amy, I'm curious if you think the new law restores Delaware's more traditional approach to corporate law or if it represents something new.
Well, that has been a charged question in Delaware the last 6 weeks or so. And there was, there were some heat and hyperbole around what happened over the last 6 weeks in Delaware, especially from the plaintiffs' bar and from some academics. But I will tell you that what I think, and what I think a lot of corporate practitioners think, is that yes, the amendments very largely take us back to where we thought we were, 10 years ago, when the market seemed to have a lot more comfort with Delaware. And I think big picture, that's things like more definition around what it means to be a controlling stockholder. When I started practicing nearly 18 years ago, you didn't think you had a controlling stockholder for the most part, unless a stockholder was in the upper 30s for voting power and had a lot of influence in board relationships. That has really crept down over time to the point that in a lot of transactions and board decisions, you're saying, do we have a controller? If we do, that has a lot of consequences. There's more definition now. The mechanisms for cleansing, like I said earlier, are clearer and simpler, but still have guardrails. When I started practicing, an independent board committee, I think, was often the gold standard from a governance standpoint. And I think these amendments take us back to that. There's more of a presumption that you'll be an independent director and that those tires can't be kicked so easily. And books and records demands are, I hope, returning to the more contained summary sort of right that they used to be. So there are definitely people out there who would disagree and say we've taken Delaware in a completely different direction, but I don't actually think that's accurate from an advice standpoint.
I'm just looking at some audience questions here. I'll try to incorporate some of those. So an audience member asks, why would a company reincorporate in Texas if Nevada were available? Are there benefits in Texas versus Nevada? And is the proposed Texas stock exchange at all relevant?
That's a very interesting one. I can start, and Amy can jump in too. I think it's very interesting. There are other considerations, in particular considerations like home state, that come into play. If you were a corporation already with operations in Texas, you might think about that very differently than if you did not have operations in Texas as well, because there can be really significant advantages for companies in being incorporated in their home state, just in terms of the courts knowing their company, political power, et cetera. If you were simply from some other state, not Nevada or Texas, I mean, yes, obviously the Nevada approach to fiduciary duties is something that companies are thinking very hard about, because there are ways in which it's quite attractive. Although, I think it definitely opens up a question that I think Grant may talk about at some point here of how shareholders think about that, which is going to be an interesting segue to that piece in a minute. Texas has had, more established courts and a longer established business court. So there are reasons such as that, even though it's a new business court in Texas, it's building on a pretty meaningful body already of law with respect to corporate governance issues that has been developed in other Texas courts over time. So I think it's very much an open question if a company really does want to consider a move, to think through all of those options and engage in a process mapping them onto the company's particular needs and scale and the types of litigation it's regularly subject to, its location, where it has facilities, all those various factors.
Great, and thank you for previewing my next question, Kristen. Are shareholders weighing in on the reincorporation debate? So Grant, what, if anything, are you hearing from the institutional investor community?
Yeah, so we actually have had a chance to talk to our institutional investors, some of them about this at least, and I think you get a lot of different opinions on this based on type of investor they are, how they choose to engage with their portfolio companies. I think this is a topic that, because we're talking about it, is getting more attention than it used to. But I think still today, most institutional investors don't have a blanket policy as to how they will approach these. They'll take it on a case-by-case basis. And I think the reason for that is they want to know why you're doing it. What are you trying to accomplish? Like, what are we giving up? What are we getting? And trying to have some narrative around that is super helpful. And I think that getting clarity on that question is super critical to this entire enterprise for thinking about moving. Like, if as a public company, you'll have to solicit a stockholder vote, have to have some explanation as to why you think this is a good idea, and then you can have a dialogue with investors. I've yet to see investors clamoring for this, and there may be some kind of edge cases, maybe some of the Elon matters where investors are saying, this person is so core to the value of this company, we have to do what this person wants, kind of no matter what. maybe that's one point of view investors will take. I think for other companies with different facts, they might have a different point of view. So if you're considering this or you're advising on this, I'd say keep that front and center at the beginning of the process, because the worst thing you can do is run this entire process, spend millions and millions of dollars, get to the stockholder vote, and then get it turned down because you haven't explained this properly. So having tight alignment early on is very important.
Well, this brings us nicely to the next topic I want to jump into, which is around process. So if a company decides that it does want to reincorporate, what steps does it need to take? And Amy, I'd love for you to start out and explore some of the legal steps, and then Grant, it'd be great if you could weigh in and talk about it from a business perspective.
So something I would say if a company is thinking about reincorporating is to at least understand at the outset that this will, in my experience, feel like a transaction, right? It requires time, commitment, resources. There's more of a known playbook now, for lack of a better word, to do this, but it still takes a fair amount of time. And so what I mean by that is under the Delaware statute, you can do this by a conversion under the statute or a merger. Those are the two main forms for moving out of the state. You need board approval for that, formal board approval and formal stockholder approval. And, importantly, you'll need board education and discussion. Whether you're a public company or a private company, your board has to understand the differences in the regimes, the trade-offs for stockholders, understand that you have to make this decision in the best interest of the company and its stockholders as a whole. So there's some real board discussion and education around all of that. You'll need significant disclosures to stockholders, whether you're public or private, and all the more so if you're public. As Grant was talking about, you want to give some thought to your stockholder base. If you're a controlled company, your controller might very well carry the majority of the outstanding vote that you need under the Delaware statute. If you're not a controlled company, like Simon announced a couple of weeks ago, you'll want to give all the more thought to investor engagement and getting your vote together. Either way, I think you want to think about stockholder relations and investor engagement. And then there are other transactional components, like you have to look at your existing governing documents, your charter, your bylaws, related stockholder agreements you might have, and think about how those work in a reincorporation. Think about what they'll look like under the next state's laws. They have to be completely revised. We try to keep them identical, but you'll still need to make adjustments. And then finally, think about things like your commercial contracts and whether there are impacts there, your debt arrangements, your equity plans and documents. In my experience so far, this has been manageable for companies, but you have to be willing to do all that.
I totally agree. I think I like to think of this entire topic as like the foundation of a house. It's there, it's dependable, it's sturdy, it's totally forgettable. And I think that people, if there's an issue and you're thinking about it, it's probably serious, but they want to just go back to the place where it's dependable and forgettable. And so you have the ability both within your company to operationalize that. I mean, there's a tremendous amount of accounting and operational impacts on this. It's akin to going public. It's kind of a phase change transformation of a company's internal processes. So do you have the bandwidth? Is it the best use of your strategic time? Have you identified, frankly, a good strategic reason for doing this? The other thing I'd also like to mention, just because this has happened in the Atlassian case when we moved to Delaware, is as you kind of dig into this, there's a million details, right? And sometimes in certain jurisdictions, this is a taxable transaction. So your stockholders to your employees. And that may have a huge impact on not only your stockholders' willingness to continue being an investor in your company, but also to employee motivation, morale, retention, et cetera. So as you just kind of work on these topics, there are a lot of issues. And I think give yourself plenty of time, budget accordingly. This is not a cheap transaction. We have great professionals on this call who, are very good at doing these, but they're not cheap. So make sure your board has plenty of time. This is exposes them to some personal risk as well as directors. So making sure they're comfortable with that before proceeding is also really important. So it could be a fun transaction to work on, but it also is something that has a lot of moving parts.
And Grant, you mentioned litigation risk, and some of this may have been covered in your answer and Amy's answer, but Kristen, in the interest of helping people to minimize litigation risk and liability exposure, can you highlight what steps business leaders should take to help ensure that a decision to reincorporate will withstand scrutiny if challenged in court, and also to protect themselves from a breach of fiduciary duty claim in connection with a reincorporation decision.
Yes, so this was a big question over the last year, particularly while the TripAdvisor ruling from the Court of Chancery was being appealed, because for a period of time, there was a much more involved process that it looked like companies were going to need to take, including a special committee and a very extensive process to be able to reach a decision that was going to be respected by the courts. After the Delaware Supreme Court's ruling in TripAdvisor, it is actually scaled back in terms of what companies need to be doing. So even for controlled companies now, it's going to be a business judgment rule test after that ruling in terms of how the board will be evaluated in making this decision. And so you do still need a board record, of course, right? You're going to have to meet the business judgment rule standard of showing how the board has thought through this issue and why the company has reached the decision that it would be best to reincorporate elsewhere. But that, that's a board record that can be put together with some discussions and deliberation by the board, very different than a special committee type process that was required for some period of time by the lower court TripAdvisor ruling. You don't need a special committee now, and the process is just generally going to be subject to, I won't say less scrutiny, it may still get scrutiny, but the scrutiny is going to be much less likely to get traction given the applicable standard.
Great. Grant and or Amy, anything to add to that?
No, I think that was well said. I think that the litigation pressure on reincorporating is significantly down in light of TripAdvisor, but you still have to give some thought to whether, there's other circumstances that will make the reincorporation look different to a court, but for the most part, it's a business judgment rule transaction now.
All right, I have a couple more questions and then I will turn to the audience. So Kristen and Amy, what are you advising clients that are trying to decide whether reincorporation is the right move for them and their stakeholders? And understanding that the answer is almost certainly fact specific, if there are certain types of companies that are more likely to benefit from a reincorporation, or if there's a framework that could help guide business leaders through the decision-making process, that would be great to understand. Kristen, do you want to go first?
Sure, I'm going to talk about it a bit more from the litigation lens, because I know Amy will cover it more from the corporate and transactional lens. So when I think about what kinds of companies a reincorporation is potentially going to make sense for, I think obviously, as we've been discussing today, companies with a controlling shareholder, you're going to want to think very hard about this because there are meaningful differences in law available to you in other states. But let's think about large public companies, companies without controllers, et cetera. Who else would want to think about this? Companies that are subject to a lot of regulatory action, which very often has meaningful follow-on shareholder derivative litigation. We see a lot of concern about that, and it is something to really consider when you're thinking about what regime you'll be subjected to on that kind of litigation as well. There are companies that just because of their size, they're so large that they're litigation magnets. Again, it is better than to at least consider whether you want to go elsewhere. In particular, Delaware has continued to hit, increasing record highs, both in terms of the number of fiduciary duty cases and the attorney's fee awards in those. This is a very real issue for large companies and highly regulated companies where there is often shareholder litigation following any regulatory or government settlement. Even if companies persist through and win in that litigation, that's a very expensive process. And if they lose, they face potential fee awards that are quite substantial, whereas in some of the other states we're talking about, Texas, for example, attorneys' fees are capped, both based on a multiple and lodestar method, whereas Delaware does not oppose a cap. That's a big difference. The other thing, when you think about reincorporating, is what kind of home state advantages there are for large corporations It has long been the case that there are a number of very large corporations that did not incorporate in Delaware. They've been incorporated in their home states. For example, last year, once Tesla reincorporated in Texas, that meant that 8 of the top 20 companies by market cap were incorporated in their home states rather than in Delaware, right? Companies like Apple, Costco, J&J, Merck, Microsoft, et cetera, because there are, this is both in the academic literature and in lived experience of companies, when you're in a place that knows you and where you have a reasonable amount of, political power, as well as investment in the communities and employees who are there, et cetera. Even when you think about that court system looking at you, that court system knows a lot more about who you are and what you do and why you do it, as well as just the potential alignment of being incorporated in the state where you have your headquarters. I'll turn it over to Amy to talk more about the corporate side of things.
Sure. So what I would say is that over the last year or so, we've certainly felt a need to keep clients apprised of, the case law, the conversations, be available to them. Some GCs have said to us, I want you to tell me about what's going on so that I don't hear it from our board members or, our CEO and so forth. So it's a fine line between keeping companies apprised, but we've never been, the sort of firm out there trying to drum up reincorporation business, which I have, honestly seen from some law firms in the market. We haven't recommended that clients leave Delaware. But what I like to do is, as we're keeping clients apprised, and certainly when clients come to us and really focusing on these questions and considering leaving, is really understanding what made them have, that reason to come to us and understand what's been bothering them or what's on their minds. And you hear a mix of things, certainly the controlling stockholder case law and transaction planning comes up a lot. I've talked to some GCs of public companies, controlled or not, where they said, I've had so many stockholder demands over the last couple of years. I'm a little fed up with that environment. There is more of a feeling that we go deep in Delaware on director independence and that we have become a more litigious environment. So I like to hear out what is on the client's mind and help them work through, what matters to you? What would you get if you moved to another state? What are the differences between the states? And just let it be a conversation that way. You've also got to consider the things that have made Delaware great, for the last century, which are real. An up-to-date statute, a very thoughtful legislature, as we saw over the last 6 weeks. They were very, very thoughtful and sophisticated. I saw Secretary of State's office that really pays attention and processes corporate filings, the market's fluency with Delaware corporate law, which allows you to do transactions, but also do things like make sure your equity issuances are done right and get legal opinions and all the day-to-day things. So that's what I try to walk through with clients and just see where their sensibility is landing on those things.
Great. I'm going to move into audience questions and reserve just a minute at the end for one more question from me. So an audience member asks if you can be more specific about the judicial overreach the Delaware judges have been accused of and your assessment thereof. Can we expect more of this from Delaware judges? What is driving this interventionism by Delaware judges?
I feel like you want me to answer that one. So look, this is one of the most written about issues, in the past year. So I'm guessing that everyone on this call is pretty familiar with it. But yes, there certainly has been a lot of press and academic debate and debate within the legal community, as well as concern from directors and corporations that as there have been continuing shifts in how some Delaware judges look at certain issues, it has become less predictable for corporations to do business in Delaware and to understand how things will apply to them. And I think, as Amy noted, there has also been very quick action a couple times in the last year from the Delaware legislature now to respond to judicial decisions that it thought raised concerns and needed to be addressed. So it is an interesting phenomenon. We're definitely continuing to see it, and it will be very interesting to see now how the standards-based parts of the new legislation get interpreted.
All right, for Grant, not asking about Atlassian specifically, but more broadly, if you were at a company that's not founder controlled, would you be concerned that asking your shareholders to move to Nevada is really asking them to give up all rights in a way that implies that the board and management may be slightly interested in oppressing their shareholders?
Good question. Well, I think stockholders and investors are sophisticated people. They make investment decisions every day as to what their needs are. I think if you have a compelling story as to why you think moving to a certain place is in the best interests of the company, of their investment, of them, I think you can persuade those people. Obviously, that's harder to do when you don't have a controlling stockholder, just simple math. But I think at the end of the day, if you have a good reason for doing this and there's something you're trying to achieve that you feel you can't achieve in your current jurisdiction of a corporation, then I think most stockholders will give you at least a listen, even if they don't agree with you. But it will take more time. I think this is something that you've seen companies try to do this. If they have to go count vote by vote, it just takes a lot more time and effort than if you can just go to a controller.
What are ISS and Glass Lewis saying about incorporating out of Delaware and into Nevada or Texas? Does anyone know?
Maybe Kristen, since you've kind of lived this a little bit.
Yes, so it's been mixed. I think with respect to Nevada, that has not been going over. Texas really has far fewer differences from Delaware. The applicable law and the bundle of rights that shareholders have there has been pretty consistent as between those states. So we have seen on a number of occasions, no opposition to those moves. Nevada's a different story. And Grant, you've been having conversations about this more recently. I think just, hearing what shareholders are saying and thinking about these issues, if you have current context to layer in.
There's a little more nuance to it. I think, depending on the investor you're talking to, they'll have an investment team and a governance team, and those pieces might move in the same direction, but not the same speed. And I think as institutional investors understand better, or even the proxy advisors, why you're trying to do what you're doing, it gives them a better picture to make a more informed decision. And I think then they can make a recommendation based on sort of the totality of the facts. And I think if you're basing it purely off, what the rights are in a charter, you might get one answer. But if you're able to add more context to business, I find you get a deeper engagement and a better listen.
A couple people are asking about California. Is California a viable alternative to Delaware?
What I have heard, without being, too anti-California, we are headquartered there. We have tons of clients in California. Is I haven't heard California put heavily on the list by clients, to be honest, given that there is, I think, some case law on the books that takes California closer to Delaware. So you're not necessarily getting a difference. And, I've heard that it's slower and different to get corporate filings processed in California and things like that. So not at all trying to be anti any jurisdiction, but I haven't really had that put in the conversations in my experience.
All right, one audience member asked about private company 220 demands. They're curious about stockholder waivers in corporate documents and how Senate Bill 21 changes 220 demands for startups. Specifically, I'm curious, given the ubiquity of waivers, whether Senate Bill 21 has any meaningful impact on private companies.
Yeah, so I run into that practice, or that question, a fair amount in my practice. What I would say is over the last decade, you've seen more and more waivers of 220 books and records rights in private company agreements, investor rights agreements, other types of stockholder agreements. Those waivers saying we won't exercise rights, we effectively don't have them, have become more common. We don't have a Delaware case directly on point, really parsing through those sorts of waivers. I think that there is some hope that if you have a waiver, particularly on the part of sophisticated parties and investors, that you can waive 220 rights, just like you can waive a lot of things in Delaware and America. There was a Delaware Supreme Court decision, Authentics, on appraisal rights waivers The court upheld waivers in the appraisal rates context, alluded a little bit to 220 waivers, but didn't fully get into them. If you think about putting them in equity plans and agreements, you should talk about that with me or other counsel or something. But it's definitely, a good issue to be attuned to as a private company.
An audience member asked, what has been the voting success of companies trying to leave Delaware? I assume in terms of trying to get stockholder approval?
Yeah, I think right now, we've mostly seen controlled companies, the big names, be able to carry the vote pretty easily. There are smaller public companies that have gone and been able to get the vote. Simon will have to do more engagement to get the vote, so we'll see how that goes. So we're kind of seeing it real time, but happy to have others add to that too.
Grant or Kristen?
I'd say given the nature of the focus on controlled companies, that cuts both ways, right? So the benefit of the controllers, they can control. So you have more success if only because of the math.
So the recent Delaware amendments were passed in part in response to concerns that Delaware law had become less predictable, but doesn't it inject uncertainty if jurisdictions can change laws when political winds shift?
I'm not sure that I would characterize this as political winds shifting so much as responsiveness to concerns being expressed by companies and directors, and also many shareholders, right? Separate from perhaps an institutional, plaintiff's bar, but shareholders that are generally concerned about companies' ability to innovate and succeed and not have enormous amounts of director and officer time as well as resources spent on litigation about things that the majority of shareholders of a corporation actually do want to see happen. So I think the innovation is good and interesting and gives companies more choices as between states, to think about and consider.
Yeah, I totally agree, Kristen. I mean, when you look back over Delaware's history, we've had big legislation that is much discussed in the past, whether it's 102B7, 203, the anti-takeover statute. We had quite a controversy over fee shifting provisions, 10 years ago. The legislature fairly quickly overturned a Delaware Supreme Court decision. We have all kinds of dialogue and practice between the case law and the statutes. That's how we ended up with a big ratification statute for defective corporate acts. That was in response to the case law. So I think course corrections have always been part of Delaware's history and a responsive statute. We just live in an era where everything is getting polarized and everything's subject to colorful commentary on LinkedIn and from the professors. And I think in the corporate space, it would benefit us to take some of the heat out and realize Delaware has always had responsive statutes.
All right, in our last minute, I want to ask each of you to share some final takeaways for business leaders who are considering a reincorporation. And Amy, let's start with you.
I mean, I think we've covered the ground a lot in this conversation, the kinds of things you need to think about as a business leader. You've got to understand the changes that are underway as we speak across the major jurisdictions. You have to think about what advantage you're seeking for your company by leaving. And, for example, if you're a private company, you should think about your stockholder base. And if you were going to do this, do you do it now? Do you do it later as your base expands? And I think public companies should think about investor engagement and those sorts of things too.
Kristen? Oh.
I'll say to hit a different point, I think Delaware's obviously just made a really big move, but it's not the last move here. And so paying attention to what's going to happen next is going to be very interesting, both in how the new statutes are interpreted by the Delaware courts, but also what other states do. For example, Texas is now, saying it's going to have predetermination of independence. That is a meaningful innovation that no other state has gotten to that yet. I think we're going to continue to see states trying to differentiate themselves in those ways.
Right, Grant?
I agree. It's great to see the innovation. I hope that gives Delaware an opportunity to further refine its law to make it even better over the course of time. Look, I think at the end of the day, management teams and boards want to advance their business goals, the goals of their strategy and the opportunities in front of them. And if this is something that can help you achieve that, it's worth looking at. If this is something that's a distraction from that, it's probably not right for your attention at this time. But I agree with Amy that it's something to keep people like me employed and sort of thinking about this, because it can be a strategic driver for your business at the appropriate time.
Okay, we are at the end of time. Thank you so much, Kristen, Amy, and Grant, for sharing your insights with us today. And thanks to everyone in the audience for tuning in. I will see you next time.